The question of when Donald Trump's rhetoric crosses the line was the subject of a pivotal court hearing today in the federal election interference case. Prosecutors and attorneys for Donald Trump met in front of a three-judge panel in the U.S. Court of Appeals for the D.C. Circuit for oral arguments. The substance was the validity of a gag order imposed on the ex-president that limits what Donald Trump can say in public about prosecutors, witnesses, and court staff. At the heart of arguments today, how do you balance the First Amendment rights of a defendant, who's also a former president and frontrunner for the Republican nomination, with the need to protect prosecutors or witnesses and prevent the derailing of the justice system? Trump attorney John Sauer was grilled by the judges for more than an hour. The judges pushed back on the idea that Judge Tanya Chutkan, who's overseeing the case, had no right to step in with a gag order.
So essentially what the district court is finding is we have a past pattern. When the defendant speaks on this subject, threats follow. And now he's making similar statements again. We're months out from the trial. This is predictably going to intensify, as well as the threats. And so why isn't the district court justified in taking a proactive measure, not waiting for more and more threats to actually occur and stepping in to protect the integrity of the trial?
The panel also did not buy the idea that Trump's status as a presidential candidate meant that there could be no restraints on what it is he says in public.
I don't hear you giving any weight at all to the interest in a fair trial. And am I right that you don't? That simply because the defendant is a presidential candidate and he wants to speak on anything he wants to speak, and he basically indiscriminately wants to post on social media, that there can be no restraint of his speech? Because any restraint, no matter how tight a nexus to protecting a fair trial, is overcome by his campaign interests.
The speech at issue and the criminal trial are deeply intertwined.
The special counsel's team did not get off easy either. With Jack Smith in the courtroom, an attorney for the Justice Department defended the gag order and said that Trump's, quote, well-established practice of going after anyone he deems as in his way is a, quote, significant and immediate risk to the fairness and integrity of these proceedings. But the judges pushed back on the scope of the gag order. A ruling is expected in the coming days, but is likely to be just another salvo in a legal battle that could sooner or later wind up before the Supreme Court. And that is where we start today with former Assistant U.S. Attorney and MSNBC legal analyst Glenn Kirshner. He was inside the courtroom for today's hearing. Former chairman at the RNC, Michael Steele, is with us. And here at the table, MSNBC legal analyst Lisa Rubin. Glenn, let's start with you. You were in the courtroom today. What do you make of the judge's line of questioning?
Yeah, Alicia, we thought we'd be in there for a 40-minute argument, and about 2 hours and 20 minutes later, we came out, and I'll tell you, it was a spirited discussion. And as you say, the judges didn't let either party off easily. They had some very pointed questions. They seemed skeptical at times of both Donald Trump's lawyer and of the lawyer from Jack Smith's team. And I can pretty much sum up what John Sauer, that is Donald Trump's lawyer, argued and maintained throughout his argument. He basically said because everything Donald Trump says and posts is, in his words, core political speech, there can be no prior restraint. There can be no gag order unless Donald Trump's speech is directly threatening of a witness such that it would violate the federal law, Section 1512, witness tampering. And, you know, the judges were having none of it. You just played a clip from Judge Garcia saying something that Judge Millett also said. Let me quote her. She said there's a clear pattern of Donald Trump issuing statements and witness threats following. And then she pointed to what she said is the accepted principle of law, that people intend the natural and probable consequences of their actions. So it was pretty clear they were not going to let Donald Trump get away with his code talking, and they were going to likely find there was some balance to be struck in favor of restraining, perhaps very narrowly, some of what Donald Trump is permitted to say and post about witnesses and perhaps about court staff. It got a little dicier when it came to the questioning that they had for the prosecution's attorney about, well, why can't they talk about not only Jack Smith, but members of the prosecution team if Donald Trump's assertion is this is a political prosecution? Why should they be prohibited from talking about not only Jack Smith, but other prosecutors and naming them. So, it was spirited on both sides. And I will tell you, Alicia, I walked out of there not knowing or being confident of precisely what these three appellate court judges may end up ruling.
Lisa, talk us through the factors at play here, what it is the judges are trying to weigh.
I think the judges are trying to weigh two constitutional concerns. One is the First Amendment right to political speech, and the other is a constitutional right to a fair trial, which impacts the integrity of the justice process. So when they express concern for the safeties of witnesses and jurors, sure, they're concerned about them as people, but their safety and security is sort of secondary to the right constitutionally to have a fair trial, because can you have a fair trial if witnesses and jurors feel intimidated, or if jurors get the wrong perception about particular witnesses because Donald Trump day in and day out is posting about them on Truth Social? So the judges are trying to calibrate that balance right. And I agree with Glenn that while they are likely to uphold some form of gag order or signal their approval for one, it's not going to be the gag order in the form that Judge Chutkan issued it. It's likely to be a much narrower one.
So let's talk about the way then, Glenn, that it could be narrowed, because there seemed to be a lot of questioning today around how Trump's attacks are leveled against people with a public profile. So think General Milley, former Vice President Mike Pence, versus people who may not have that same type of public platform, and the way in which that could potentially impact testimony. I wonder if you see that axis, public person, not public person, as potentially being one of the ways the judges use to refine this gag order.
Alicia, you're exactly right, because that was a subject of debate and discussion and again, very pointed questioning when it came to Jack Smith and his team and the arguments they were making. The judges said, listen, if Bill Barr, for example, a public figure, holds a press conference and says Donald Trump lied about X, Y, and Z, shouldn't Donald Trump then be free to respond with, and I'm going to use the language of the hypothetical that one of the judges posed, that Bill Barr is a, quote, slimy liar? And then the discussion actually, I'm going to use the word devolved, into a debate on whether, if Bill Barr accuses Donald Trump of being a liar, can Donald Trump call Bill Barr a liar? And I think that prompted perhaps the only chuckle in the courtroom when the attorney for Jack Smith's team said, well, perhaps he could say he is an untruthful person, but not a liar. I'm not quite sure what the distinction is there, but you're exactly right. They had some pointed questions about public figures, and isn't it only fair that if public figures like Bill Barr and Milley and others are going to make accusations against Donald Trump, setting aside who's telling the truth and who's not, shouldn't Donald Trump be able to respond, perhaps in kind? And I think they were trying to distinguish the public figures from the witnesses in the case and the court staff, who, the judges said, does he really have a right to start naming, or as he did in New York, post a picture of a court clerk? So it does seem like they're going to have to engage in some line drawing and give some direction back to the trial court judge, Judge Chutkan, about sort of the constitutional do's and don'ts of a permissible gag order.
Michael Steele, let's talk about political speech. The judges seem to suggest that a gag order could serve as a prophylactic to prevent threats, intimidation. What does it say that this is the conversation that these judges are having in the lead up to this trial and to 2024?
Just tells you how much Donald Trump has twisted everything into a knot. This is all deliberate behavior. This is all about trying to bend the system to his will, to his direction, confusing political speech with what Donald Trump is saying. One of the big distinctions for me, and I really, appreciate the way Glenn kind of laid that out there. But at the end of the day, what got us here are the threats, the actions that his followers tend to take when they hear this hot rhetoric coming from him. And what Donald Trump is doing is ostensibly using the First Amendment to wrap himself in, to say that I can say these things and that I'm not responsible for any of the consequences that come from it because it's all political. Well, it's not. It's not. the person who goes after a judge or goes after a clerk or goes after a prosecutor, stalks them at home, is no different than yelling fire in a crowded theater. There's a consequence from your words. People are harmed or potentially harmed. And that's what the system is trying to safeguard against, protecting his rights, at the same time trying to protect the rest of us from him. Because that's really what it boils down to. And that's the balancing act that the court now finds itself in, trying to strike this unique balance, because we have a political actor who is so distorting what is otherwise, or have in the past been, much cleaner lines when it comes to the behavior of politicians relative to the court, relative to the public.